Morning, everyone. Thank you for joining us for another Minnesota Matters. I'm Tess Rice. I'm MBA's General Counsel. I'm joined by Teresa Kuvas, MBA's Government Relations Manager. She's going to talk about, just to give a quick legislative update. Tom Boswell-Healy will follow with some discussion of the impact of death on bank accounts. And then Keith Johnson's going to talk about some frequently asked questions he's been getting. If you have any questions for our speakers, please put them in the chat and I'll keep an eye on those. And I will turn it over to Teresa.
Perfect. Good morning, everyone. I'm going to try and talk slower today. While I know that the legislature is moving very, very quickly right now, I don't want to rush through everything, much like they are doing. So the legislative session started beginning of January. So for anybody that attended Bank Day 2 weeks ago, thank you. Session's been moving very, very quickly. We are starting next week will be the 7th week of session. I feel like it's been the longest 6 weeks of a session that's ever happened. And so we have 13 weeks left. So they have to constitutionally adjourn on May 22nd. So for the last 6 weeks, they've been rushing through policy committee hearings, policy bills, because we won't actually get to the budget conversation until the beginning of March. The governor had to release his budget proposal at the end of January, but that's before the budget forecast ever comes out, which will be out on February 27th. So on February 27th, the budget surplus or the budget forecast will come out, and that's what they kind of dictate the budget for the next biennium off of. So then the governor will have to do his budget proposal. There's obviously a lot of money sitting out there, a lot of one-time money. So some of these policy bills will kind of be based off of some of that one-time money, what's going to happen with tax bills. I'm not going to predict anything right now. So kind of a lot of what's going on, a lot of policy bills, right? So the employment law bills, the employment bills are going through really quickly. Today on the House floor, safe and sick leave will be up. There's probably about a dozen or so amendments that the Republicans will try and do with that bill as well. Paid family medical leave is a bill that will have to go through about 16 to 18 committees in the House and the Senate. That one was moving very, very quickly. It still remains to be moving quickly in the House. That would give 12 weeks of family leave and 12 weeks of medical leave mandated, and then probably to pay for that program would probably end up being a tax on employers as well, and a little bit from the employee. So that one remains going to be going quickly. However, the Senate, the Senate Democrats have a 1-seat majority. So it's 34 to 31. So the question is, will things get slowed down in the Senate? And they seem to be starting to slow down. In the judiciary hearing a couple of weeks ago, one of the senators that's in one of those swing districts that was kind of one of the ones that tipped them into the majority did start questioning a lot of what was in the bill and how to change it. So the question is, will they just push everything, get it off the House and Senate floors, and then really have those discussions in a conference committee? That's one we're watching. We're members of the chamber, United for Jobs Coalition, and have kind of been putting our name on flyers with that, but that's kind of more their specific area of expertise. Cannabis continues to move really, really quickly. 2 hearings a week again in the House and the Senate on that one. That one, the MBA has been following as we've gotten quite a few questions. We have met with both of the authors in the House and the Senate to kind of give them an update on what would happen and how the banking industry would react to a legalization of marijuana in the state. We've gotten questions from some about, is there any amendments that can be done to help financial institutions when it comes to banking? And we've told them that it's a federal issue, that if Congress could pass the Safe Banking Act that allows states that have legalized marijuana to be able to bank it, that would be much more beneficial than anything that any state can do. For that, we've also said, as we've been getting questions, I'm like, in none of the states that marijuana has been legalized has banking it been the roadblock to stop the bill. So we have said we don't take a position, but we will continue to follow it. We will just keep informing them of the difficulty of banking it when it does pass. Financial literacy is one that is going to be coming up. We are supporting a bill that adds financial literacy curriculum into the high school, into the high schools for your senior year. There's a coalition of people that are kind of getting behind this one. And the question really comes down to, will the teachers union, can they handle the language? Will they be okay with the language? There's a group out there that's willing, that's actually gone to the legislature for funds to teach the teachers on the financial literacy. We think that it's really incredibly important. You know, I was talking to a legislator the other day and they're like, well, you know, that's not going to pass because, you know, we just don't want to add more things to the curriculum. And I think everybody believes that this is probably more important than a lot of the stuff that's in the curriculum for those seniors that are kind of getting out, you know, when it comes to student loans, when it comes to budgeting, when it comes to, you know, credit cards, mortgages, so much more. It's important, you know, to have those financial conversations. And I think only right now, I think 7% of students are taking it by choice. Another bill that the MBA is actually sponsoring, and I just finally gotten the bill out of the revisor's office, and we've started to get our authors with it should be introduced next week in the Senate. And then we'll probably introduce it the next week or the following week in the House. And this is one that we are definitely excited about pushing. And as I've mentioned to our authors, it's fairly simple, fairly boring. I did, before I hand it over to Tess and she'll tell you about the bill, I did have somebody that passed me in the hall yesterday and said, you know, there's not a lot of banking issues at the Capitol this year. And my comment to them was, let's not say that out loud, because there's always ideas of things that people would want to do to us. You know, there's payday lending bills out there. There's other ideas on ESG, on the environment, you know, on the environment, social and governance stuff. There's always ideas out there of things that could come up. So we kind of like to kind of keep those at bay. But the bill that we're very interested in is our bill this year. And Tess is going to kind of talk about the 2 points in that bill.
Yeah, I think we're being very bold this year, Teresa, trying to do something in this environment, but we're pretty excited about it. One thing would allow banks to operate part-time branches. So currently, you know, your branch has to be open Monday through Friday, you know, during, I think the Commerce Department lets banks close at 2 at the earliest. But this would allow a bank to be closed for 48 consecutive hours on a Monday to Friday basis, meaning you could just be open on Wednesdays or any other kind of schedule that fits within that. We think that this will help, especially with rural branches, keeping them open. Maybe there isn't enough need to justify them being open full time, and this might prevent them from needing to be closed. And there's also issues with staffing, of course. And so we're excited about that one. And then the other one has to do with the director's exam or audit that state chartered banks have to pay for. It's expensive, and we've heard from bankers that it really isn't necessary. We've talked to the Department of Commerce about it. They agree that their exam covers all those issues, and so it is something that isn't needed. So we have language that would repeal that requirement in state statute and in the rules. So we're hoping to get the Department of Commerce's support for both of these. We think that it's likely. There certainly will be neutral if nothing else, but we're hoping that they will support us on that. So we're pretty excited about having something proactive this year.
Yeah, and the only roadblock I think at this point is, as quickly and as fast as session is gone, they are bound by deadlines. So their first deadline, so we would need to get this, it would really only have to go through one hearing in Commerce. So we just need to get that one, at least one of them done by May 10th or by March 10th, and then the second one done by March 24th. So we do have some time, but when you start looking at how many committee hearings there are left in certain committees, there's only probably 8 committees that hearings left in the House Commerce Committee. So we got to find, you know, hopefully only 2 minutes would be what it would take, but we're excited about that. So that is the legislative update.
Thank you, Teresa. All right, I'll turn it over to Tom. He's going to talk about the impact of death on bank accounts. And Renee wanted us to let you know, I'll handle this plug, Tom.
Okay.
That May 9th, there is a death in the bank account class that will be held in person at the MBA. Okay, ready, Tom?
Yes, I'm ready. Yeah, so I'll just say a couple highlights and also plug the Minnesota Deposit Manual, MBA Deposit Manual as well, that has a chapter 19 on death and incompetency, and there's some information sprinkled throughout about a death and how that impacts deposit accounts. But kind of just to level set a little bit, so when we're talking about death here, we're obviously just talking about individuals. So if you have an entity, an LLC, corporation, anything like that, they can't die. So there's no concern there. If even if it's a single member LLC, the LLC still continues after that single member dies, and there should be information in their constitutive documents on how that happened, what happens after that single member dies. Partnerships can be a little bit trickier. Sometimes when a partner dies, that could end the partnership, but that's all going to be in the partnership documentation as well. So mainly just talking here about individuals, which could include also sole proprietorship accounts as well. First thing, kind of two basic arrangements for those multi-party accounts. You've got tenancy in common, which you don't see very much. That's the one where you have multiple parties. And then if one party dies, their interest in the account goes to their estate afterwards. So that's pretty uncommon. And, if you're looking at doing that, I would just make sure that the bank understands all the implications, that anything you have in your agreements, your terms and conditions, covers that tenancy in common aspects of ownership as well. And it's really something that, I try to talk banks out of doing. You're certainly free to do it if you want to, but it's just easier to stick with that right or survivorship account, joint account as well. So with the right or survivorship, that's when, you have two owners, one dies, all interest in the account goes to the remaining owner. So another multiplied account that comes up too is payable on death, payee or beneficiary. And that's just the last surviving owner of the account. When they die, all interest in the account then goes to the beneficiary or beneficiaries. There could be multiple as well. And just to be sure too, that it's coming up a couple times that if you're adding a beneficiary, it obviously has to be added before all the account owners have died. So it's got to happen during the lifetime of the account owners. I've seen some where they have a will or something that's brought in afterwards, said, well, they wanted me to be payable on death. And you usually do that during the lifetime. There are some mechanisms where changes by will can happen. They need to give the written notice to the bank before that. And so let's see, another. It's also government agencies can also take deposit accounts upon death as well. For medical assistance is the typical one, but they can have an interest to recoup some of the money that's paid. As far as what happens upon death, if all the owners are dead, and whether or not you can pay certain items, you typically can't pay until you find out about the death. And then you also have 10 days after death where you can pay and certified checks and other items, unless somebody has requested a stop payment on a particular item or all items. And that has to be a person with an interest in the account. So it's going to be an heir, personal representative, something like that. And all of this too, these should be items that are drawn or created prior to death. So not items that are written post death. Another piece that comes up with that too, federal benefits through ACH credits. If you have that, as soon as you find out about the death, if the agency is not aware about it, and you've received an ACH after death, you should return the ACH to the entity. You're going to either have an R15 where it's the account holder is deceased, or if it's a representative payee situation, that's an R14 return code. And if you do make a return with one of those codes appropriately, then you've satisfied all the requirements to return the payment and also notify the agency of the death. So that's good. And then as far as finally dispersing all the funds from the account, if they're not talking about payments, but just closing the account and dispersing it out to who's authorized to do it. As long as you follow the steps laid out in the Minnesota Multi-Party Accounts Act, you're discharged from any claims under that. Typically, if there's just one person, if there's an individual that's claiming, they're going to be a personal representative or some kind of heir. You get the proof of death, appointment letters from the probate court, or, personal appointment letters, or it's going to be letters testamentary, something like that, to show who's eligible to get the funds. Another method of getting the funds is with that affidavit of collection of personal property. Those are going to be just for small estates. So in there, the thing that trips up banks, I think, most often with that is that the $75,000 estate threshold is the total estate of the decedent, not just the bank account at your bank or other banks. It's going to be their total estate, has to be $75,000 or less. And then as far as the affidavit itself, it'll state that, make a statement that the estate is the appropriate amount. 30 days have happened since the death, that there's no personal rep that's pending or already been appointed, and that the individual claiming payment is entitled to payment. So they're either an heir. Again, there could be a government agency that elects under that as well, as well as other debtors. Yes.
So I know we get a lot of questions about that threshold amount. It isn't the bank's job to police that and be a detective and find out what size their estate is. But when it comes into play a lot, I think, is when they say that the estate's less than 75,000, but there's more than that in the bank, right? That hasn't been paid directly to.
Or if they have, or if
beneficiary or
that they own property and you have like a mortgage on the property, that they have more interest in the property than that. That's where it comes in. I mean, typically I get it where questions, when I receive questions about it, it's from banks said, well, you have somebody who died and the son came in and says, how do I do this? There's not very much money in the account. And then they start to tell them about the smallest estate affidavit, and you just want to, if you're describing that as you want to be clear in that it's the total estate and not the full estate, but they should really be going for legal counsel to their own attorney, not relying on the bank. And you shouldn't obviously be providing legal advice.
Tom, we had a question about when you have a beneficiary named in a will. They asked that if you could expand on that written notice.
Yeah, and if it's something where you haven't had notice prior to death, they have to make a written claim, and they've got a limited amount of time. Let's see if I noted that. It's I think it's that's the state I had, or call the exact limited time, but there's they have to provide a written claim that they made something, a change of the account via will, and that it's effective. And if the bank doesn't receive their written claim, then they don't have to adhere to it and can pay out just according to the statute normally. So it's really going to be, if they say that there's a change made by will, tell them to contact their own attorney and how to make the written claim to make those changes to the bank account. Was there another one on there?
Yeah, there is. Well, one asked about, is there a workflow or diagram for the Minnesota Multi-Party Accounts Act? I know that in the deposit manual, in the death chapter, we call it.
Yeah.
There are I think there's some flow charts in there.
Yeah, I think there are. I didn't really look at the flow charts, but I think there are some flow charts in there on how to do that. The next one, as far as the live-in girlfriend using the affidavit for personal property, that it would depend on if they're the heir. They would have to be claiming that they're an heir. Again, it's similar to what Tess said about the amount of the estates. The bank employees don't have to do anything as far as verifying whether that claim is valid. That's what the affidavit does. They're signing the affidavit. If it's incorrect, then the other parties that actually do have the interest will go after the person that's making the false claim on the affidavit. And it's not the bank's responsibility.
A girlfriend would probably need to be named in a will or something like that, because she's not a blood relation or a legal relation. She's not going to qualify under other parts of that statute. That would, people who are related can use that affidavit for collection, but since she's not technically related, I think she'd have to be, isn't being named as beneficiary or something one of the thresholds for using the affidavit?
Yeah, so you could do that as well. It's just, and again, it's the The bank doesn't have to vet that claim. So it's that person is responsible. Yeah, it's limited persons. They have to be an actual interested party, and there's a definition of interested party. You know, the heirs are the certain ones if they've been named a beneficiary is another. But that's where creditors that also can come in. They're an interested party as well, and the governmental agencies if there's been some sort of medical assistance is the best example. I did see one in the chat. Was that about
Yeah.
other different states?
Yeah, if a customer lives or died in a different state, but we are a Minnesota bank, do we use the Minnesota affidavit or the laws of the other state?
Yeah, I would use the Minnesota affidavits, and two, if there's been a personal representative appointed in other states, you could follow that appointment as well. There's an additional time frame, I think 60 days on that after death to get that, but you can transport a personal rep appointment from another state into Minnesota as well.
I think that's it for questions.
Okay.
Did you have anything more, or should we turn it over to Keith?
I think that was most things. The only really the only other thing I wanted to say was about set off. If you're all going to set off, it's best to do it as soon as possible. So make that decision on whether you're going to set off. And you have best support for set off if you have it mentioned in your note agreements that death is an event of default and it will accelerate the credit. So which is pretty common, but just to make sure that you've got that in there as well.
Yeah, very important. Well, thank you, Tom.
Thank you.
We'll turn it over to Keith, who's going to talk about whatever he wants to talk about, right, Keith?
Oh yeah. I always got good things to talk about. I got random stuff to talk about. The death of the bank account one's always a good one because I get a lot of questions about that, but this will be a little bit different. So first question I wanted to go through is one that we were getting kind of a lot this past year because it was an issue that came up in 2022. And the issue was whether or not a bank needed to start reporting IRA withholdings to Minnesota using Form W-4 MNP, like it does with pensions and annuities. And this question came up last year, and it was one we sent to some CPA firms to see if they could figure it out for us, and they didn't really give us any clear answers on it. And apparently back in 2022, the Minnesota Department of Revenue was starting to tell banks that they needed to do this IRA withholding using this form. But it wasn't really clear why, because in the directions for the 2022 form, it does not say in there that it's supposed to be used for IRA withholdings. The federal form does. And it wasn't clear on the Minnesota Department of Revenue's website why it should be used for this. So there was just no information other than some anecdotal evidence from bankers saying they talked on the phone with somebody who they couldn't specify at Revenue saying they had to use the form. So there wasn't really a lot of direction for that. But now on the 2023 form, it says use it also for IRAs, and the Minnesota Department of Revenue's website has a page about this form as well. And it says on there to also use it for IRAs. So it was very timely, an entire year late. So that was wonderful. But it is more clear now, supposed to use that form for IRAs in addition to pensions and annuities. Next question that I get fairly often is about guardianship accounts and when a guardian has authority to open a guardianship account and whether or not they have any power over the ward's money. So this is a very kind of confusing question for banks. And in Minnesota, there's a guardian, there's a conservator. They're two different appointments and they have different powers. A conservator has power over the person's estate, not to be confused with a personal representative's power over the deceased person's estate, but it's essentially the same thing because it's just their money and their assets. So the conservator controls all of that. A guardian just provides care and takes them, if it's a child, you take the child to school. If it's an elderly person, you take them to medical appointments, you take them to grocery stores, you do whatever it is for their actual just day-to-day care. But the problem is that in Minnesota, the statute that gives guardians power doesn't say anywhere in there that they have authority over the person's money or their estate or any of their finances. There's a brief mention to finances if they need to apply for some government benefits and there's no conservator and their guardian could apply for them in that situation. So the question is whether or not a guardian really can open a guardianship account at all if they just don't have this power. And The problem is presented this way. They have to provide all of this care in the statute, which costs money. But then the statute says the guardian doesn't need to spend their own money. So now we have an impossibility, right? You have to provide all this care as the guardian, but yet not use your own money. So how are you going to pay for it? That's sort of the reason that the manual, our MBA deposits manual, talks about the ability to open a guardianship account, because it's just not possible to pay for all of this stuff unless you have an account. So that's why they could potentially have the power to do it. You know, ideally, it would be for relatively small amounts of money, and the manual just kind of suggests $5,000 as a limit. So if it's a substantial amount of money, or they're regularly getting a lot of, Social Security payments and all sorts of other income on a regular basis, it's better that there's a conservatorship appointed. And when somebody comes to the bank and says, well, how do I do that? The answer is always tell them to go talk to their own attorney, because you don't tell them how to get a conservatorship appointment. But it's just a lot of a confusing discussion for people to have, because they think as a guardian, you just have control over everything, and it's just not how it works in Minnesota. So that's one reason why the manual kind of discusses the ability to have a guardianship account. Next question that I get all the time, one we've talked about kind of often, is how does Minnesota handle APR calculations for various fees, bank charges in a loan transaction, particularly the loan administrative fee? All right, so this is how this statute works. Minnesota is a weird state in that we have like 6 lending statutes or something, rather than one, which is what you would think would probably be sufficient. But anyway, we have multiple ones. And for the most part, banks will lend under Minnesota statute 47.59. And it's kind of the most in-depth one, and provides just usually the best kind of benefit to the bank in terms of all these other charges that can go in there. So in that statute, the important one is subdivision 6, which is where the loan administrative fee is. It's also where things like the delinquency charges are. So those fees, the language works this way. It says that if the fee you're charging fits within that language, it's not part of the APR calculation. So for a loan administrative fee, that fee for a kind of a small loan, it's $7,776, and that gets adjusted every couple of years with inflation. So, it'll probably change again, I think maybe in 2024, but I can't quite remember. So if the fee is $25 or less, the loan is $7,776 less. You charge that fee, and it's not part of the APR calculation. You can charge a higher fee than that. It'll be in the APR calculation. You can charge a $25 fee or any fee on a loan over $7,776. It will be in the APR calculation. So that's the difference. And that's how that statute works. It says whatever the fee is, a late charge, if you have a late charge for some reason that was higher than what's in the statute, it'd be in the APR calculation. That's the problem. So when you're reading that statute and the list of fees, as long as whatever it is, the fee and the loan fit within that language, it's just not part of the APR calculation. So that's kind of a good thing to remember. Do we have any questions?
No, you don't really. So that's the state statute, right? So when you're putting your loan disclosures together, you really care about Reg Z, right? That's
Yeah.
what you're disclosing on the document. So this really comes
Right.
up when they pay a loan early.
Yep.
And you've got to check and make sure like what kind of refund they're entitled to.
Yes, so then when they pay it off early, you kind of recalculate the APR because you have a lot of these fees, and so it might change what the actual rate is. And you disclosed, the rate over the life of the loan, and basically, with all those fees that go in there. So when they pay it off early, calculation is going to be different. So even if the APR ends up being, out of tolerance, to use the language they'd be familiar with, you just wouldn't have to refund it because it's just not a finance charge, and the finance charge is defined in Regulation Z, and that's what the statute incorporates. So that's kind of, it's unfortunate because the statute's written very confusing. It's just not an easy read, and that's why I think that there's always a lot of issues with that. On the federal side, though, it could be possible maybe that a regulator would come in and say that, a fee that we don't consider to be a finance charge in Minnesota is a finance charge, in purposes of Reg Z and everything. But that could be possible. But that's
Yeah, but really the point is that this fee, this loan administrative fee, and you need to call it that, doesn't have to be refunded
Yes.
if the loan is paid off early. So that was the way for the legislature to say, okay, you're gonna, even though we do require you to refund some fees, this one for sure you can keep for your efforts. It's not
Yeah.
much, but it's something.
Yeah, it's yeah, it's not a whole heck of a lot, you know, it's a small loan though, might make a difference here. Next question that I get sometimes here and there, not a whole heck of a lot, and it's kind of an interesting one, but it's what does a bank do when they found out a customer has been engaging in internet gambling and whether or not it's illegal in Minnesota? So for the most part, banks don't really come to us with this a lot of times because they're not really scrutinizing a lot of transactions that happen on people's accounts. It's just happens that they discovered it for some other reason. You know, they saw that they were engaging in this. And the answer is yes, in Minnesota, online gambling is illegal. And I just imagine that it's something that the legislature may change at some point. And I'm not exactly sure on the state to state rules for this, but last I saw a graphic for it comparing the different states for internet gambling, Minnesota seemed to be in the minority for states that outlawed internet gambling. And every year, more and more states legalize it. So I just imagine that will happen at some point. But you know, in any event, yes, the criminal statutes do make this illegal. It's Minnesota statute 609.75 and 609.755. 609 is the Minnesota Criminal Code. So what do banks do when they discover it? I suppose they probably just file a SAR for it, let law enforcement handle it if they really want to go after somebody's $50 DraftKings bet. I doubt that's going to happen, but I mean, yeah, it's a crime, but you know, it just doesn't really seem to be much of a law enforcement issue. I've never really heard of anybody being prosecuted for it in Minnesota, but you know, that's possible. Next,
And there is legislation this year at the Capitol
oh, is
to
there?
legalize
Okay. Yeah, so well,
all
there
different forms of gambling. Yeah.
Yeah.
So we'll see what comes out of that. We'll be sure to let
Yeah.
you know if something changes.
yeah,
But Keith, look at, we've got to 9:32, so we are past our time. Even though I know that you could say interesting things for another half hour.
I know, I could. Oh, another one. Wait, really quick. So another one I
Okay.
get every month is whether or not the bank can get a subpoena that's faxed to them or emailed to them or something like that. So in an effort to cut down on costs and everything, subpoenas can be sent electronically in Minnesota. Minnesota rules of civil procedure 45.02A, 5.02B, and Rule 1401A7. So basically it just says that you can serve a subpoena in any manner provided. The manner provided says that it can be electronic, and then electronic is defined as, you know, through a computer or a fax machine. And this also applies to the criminal code as well. For 3305 is the rule for that, which is for electronic warrants. But anyway, yes, if you get a subpoena electronically, it's still enforceable.
Excellent. All right. Well, thank you so much, everybody, for joining us this morning. Remember, we're here if you have questions, particularly Keith is here if you have questions.
Yeah.
You can call him or you can email him at legal@minbankers.com. Have a great day.